A very good evening to all our participants. We thank you for joining us on this special webinar on dissecting Apex Court's verdict on PMLA provision with none other than Additional Solicitor General, Senior Advocate N. Venkataraman sir. Venkat sir completed law in the year 1989 at the Madurai Kamaraj University and commenced practice the same year under senior advocate late Mr. C. Natarajan sir and worked under him for 14 years before commencing independent practice in June 2003. He was designated senior advocate in the year 2006 by the Madras High Court. In 2020, Sir was appointed as the Additional Solicitor General of India in the Supreme Court and has completed over 30 years of professional practice in the fields of indirect tax, direct tax, and international tax. In the last 10 years, Sir has been doing extensive work in constitutional law, various regulatory matters, negotiations, and finalization of commercial disputes, framing and settling contracts and arbitration, and has been involved in matters of substantial public importance, such as the famous Sabri Malai matter before the Constitutional Bench of the Supreme Court, Article 370, and similar such issues. Sir has also argued before the 9-judge bench on the entry tax matter and has also appeared before 23 high courts spread over various states, various tribunals, advanced ruling authorities, and the Security Exchange Board of India and Security Appellate Tribunals and other forums. Before I hand it over to Sir, I would like to take the opportunity to apprise you all that in the last 10 minutes of the session, we will host a dedicated question and answer session. For this, you may post your queries in the Zoom question and answer box. With this, I now hand it over to Venkat sir.
Sharada Sharadamboja Vadana Vadanambuje Sarvata Sarvata Smakam Sannidham Sannidham Kriya. My dear friends, Arun, Tanmai, and everybody else, Namaste and good evening. A fairly interesting new subject and an interesting new judgments, which we are likely to now discuss for a few minutes. But let me preface before I proceed to speak. The endeavor shall be to discuss what the latest judgment on PMLA and the Binomy Transaction Tax, Binomy Transactions Act seek to say, with one rider that today morning the Honorable Supreme Court was pleased to issue a notice on review on this PMLA case limited to 2 questions. Whether this enforcement case information report equivalent to FIR, a copy should be given, and this reverse burden of proof. But since the judgment is not made sub judice as on date, we therefore took a call to proceed with the discussion. So I say this with this writing. The whole idea of this discussion is going to be a broad understanding of what this PMLA law seeks to say. And at the end of the discussion, we will also try to refer to the Binomy Transaction Act judgment and the areas where possibly there is an overlap or an intersection, and how different benches have viewed the issues from different perspectives. So, before we step into understanding what this judgment says, we should have a clear idea about how economic laws operate in this country. That's very important. See, every civil law will have civil consequences and may also have criminal consequences. And criminal consequences normally will be dealt under the criminal jurisprudence, and the civil consequences will be dealt under the respective civil laws. It's a broad understanding which we must have. Just to cite you a few examples, may it be Companies Act, may it be SEBI Act, income tax, GST, customs, which comes very close to what we are going to talk about. All these economic laws and taxation laws deal with contraventions, deal with penal consequences, and deal with also prosecutions. Besides that, they also deal with attachment of goods, attachment of bank accounts, seizure, confiscation, which is forfeiture. So they all deal with these subject matter from a civil liability perspective. But this infraction and contravention can also lead to criminal consequences. So, before this judgment came to be delivered, both these judgments, let's take one example, say under the Customs Act. You import goods. Suppose computer parts are prohibited. Somebody misdeclares it as some toys and ensure first few inches are arranged with toys and beneath that it's all computer parts. And that's imported into India. And the customs authorities seize the goods. And they cut open the goods and they find beyond a few inches, everything in the container is only computer parts, which is prohibited. Then an infraction in law happens. So what are the consequences? Besides fastening you with a customs duty, which is a tax liability, an interest over it as compensatory, the law also allows you to do three things. It allows you to penalize the import and the importer and people who are associated with that contravention. So penalty is one consequence. Second consequence is that qua the goods, you are entitled to confiscate it and make it as the property of the government of India. And of course, allow redemption of the goods on payment of redemption fine, unless otherwise they are prohibited goods and where it's dangerous or it's not approved or healthy to give back the goods against the redemption fine. So that's the second vertical, confiscation. And the third vertical is prosecution. Because this is a case of misdeclaration, and suppose they are considered to be even smuggled goods, then the infraction is of a higher order. So it goes on and on. So what we need to understand is, in economic laws, you will have a particular underlying substance of economic activity or economic process as the basis for the law to operate. It can be a tax law, it can be a regulatory law, it can be anything. But they are all invariably special laws, tracing its sources to different entries in the Constitution. So, in a case of this sort, what do? You are entitled to arrest. You are entitled to interrogate. And the criminal jurisprudence will take over in those aspects. It will be tried in a criminal court. The customs proceedings of misdeclaration, holding whether it's a smuggled goods or not, fastening with tax, interest, penalty, and confiscation, that will go simultaneously as the departmental proceedings and a hierarchy of appellate forms. So both can happen simultaneously. There are cases where one may not even attempt to do a criminal prosecution, may stop with just the civil liability and its consequences. So the matrices will depend based on the intensity of the matter that happens. PMLA and binomy transaction is one such law from a perspective sense. The whole idea of giving this background is to only bring that home. If somebody launders property, for our understanding, say money, because the definition of property is very wide under the law, then it leads to a contravention of that law, and it leads to certain consequences. Earlier, when such things happened, you were trying them as offenses under the respective enactments or under the IPC or under the different legislations as offenses. So it was a collective decision across the world. There are a lot of conventions, everything is recorded in the judgment, which finally culminated in India also agreeing to align with the global thought process that we should also prevent money laundering. And that's how this legislation came into force in 2003. So, what is the underlying activity which this law seeks to focus? It seeks to focus the activity called money laundering. Money doesn't mean only cash or bank transactions. It is actually property laundering. For convenience sake, we call it money laundering. And the judgment brings it out very clearly. It has three basic components: the placement, the layering, and its integration. The placement is moving the proceeds through the activity of crime. But when you move it, you layer it as though this is not an illegal transaction. And you allow it to integrate at the terminal point for the person to actually be the recipient of the laundered money. So this is a special law, number one, a special code, number two, and more importantly, Supreme Court makes it very clear, you can neither brand it as a punitive law nor as a regulatory law. It's a combination of both, and therefore this is a sui generis law. This is a foundation. It's a species of its own kind. Now, there are only three major focal points of this law, which this judgment seeks to address. The rest is all details. As I said, we should have a broad idea of what this law seeks to say. So, they talk about attachment, both provisional and final. They talk about the adjudication process. And they also talk about the process of confiscation. So these are the three major focal areas of PMLA. So if you understand these three areas, then we can possibly navigate into the law and interpret it depending upon the facts of the case that arise for consideration. The first attempt this judgment seeks to make is in defining what is a proceeding. So proceedings do not necessarily limit themselves to a court proceedings. The expression judicial proceedings has been given a meaning to say recording statements, even inquiry, investigation, everything will come under the terminology proceedings. This is a very important aspect which the judgment has laid on, because this expression proceedings appears in most of the tax and regulatory laws. And therefore, the bandwidth needs an identification, which this judgment seeks to say with certainty. Then it seeks to explain two important definitions: money laundering and proceeds of crime. Because the whole edifice of this law is based, they rest on these two pillars. What do you mean by money laundering? It is what the judgment puts it very clearly in terms of the definition, process or activity. And the process or activity is taking 7 different shades in this law: acquisition, use, possession, concealment, disguising, projecting, and claiming. So, if anyone is involved directly or indirectly into any one of these activities, then he can be booked for money laundering. Acquisition, use, possession, concealment, disguising, projection, claiming. So the first question that was debated in this judgment and ruling has been delivered is, should you have to prove every time that the laundered money has been claimed or projected to be legal money? Is that essential component? How it was earlier and how it became or another and can be read as or all this. None of the discussions, the court made it very clear. We can't, this will simply frustrate and defeat the very objective of this law, including fatwa's basic guidelines, and it will not be in alignment with the global thought process. If you insist that it should be projected or claimed, then what will happen to those cases where there is a concealment, where somebody disguises it, where somebody possesses it and conceals it, where somebody uses it in a secretive way, where the acquisition doesn't come within the legal radar at all? So that will be a onerous condition to impose or read into that law. So don't insist the satisfaction of these two ingredients in every case for you to say the offense stands committed. This is one clear ratio emerging out of this law. And they give an ancillary reason why when they lay down this law to say, look here, unlike core criminal laws, where a commission of offense gets detected, tried, and punished. So it is, those laws are generally punitive. Whereas money laundering is a sui generis law. It is also partially regulatory in nature in several aspects and dimensions. And therefore it is preventive, also preventive in nature. So when the law is preventive in nature and also punitive, then two things, don't insist on two things. Don't say projection and claiming to be a criteria. nor should you insist that this laundered money actually gets integrated into the economic mainstream. That proof. Because it will all slowly lead there. So these two conditions are not necessarily concomitant to conclude money laundering. The judgment says it without any ambiguity. And it also says one more aspect very clearly. The third aspect is this law came on a particular day, and there has been some 11 amendments have been carried out between 2003 and 2019. So what happens to offenses committed prior to its amendment in bringing, say, scheduled offenses now and then? For which the court concludes that the central axis starts moving not based on the date of commission. As long as it is continuing in one form or the other, after its inclusion into the schedule of scheduled offenses, then that is good enough for the activity to be considered as liable. So if somebody says acquisition has taken place and concealment is happening only post the offense, therefore both should go away, or concealed person alone should be caught and not the person who facilitated the acquisition. No. If any one of the ingredients continue post the offense period, post the inclusion of the scheduled offense, that should be a strong ground for you to invoke this law against that transaction. So these are in short the ingredients of the definition of money laundering. Second comes, so money laundering is process and activity based. Now we understand a process, we understand an activity, we understand these ingredients, but what is the underlying happening? That they define it as proceeds of crime. So there are just three important vital ingredients which the judgment seeks to refer to on proceeds of crime. Proceeds of crime should be property as defined under the PMLA Act. In fact, we had an interesting case which we are still debating in one of the courts. Somebody argued, I have an enforceable debt, an actionable claim. So under the Companies Act, I'm entitled to show that in my balance sheet as an asset. And therefore, if that asset is identified as laundered money subsequently, will it become proceeds of crime? Is one question which we are debating in one of the courts. So economic activities will keep churning out in plural dimensions and in multiple combinations. So we should have the flexibility to identify them and see if it satisfies the underlying guidelines, then the offense is made whole, is what we should try to proceed with. So property, it should involve a property. That's the first important ingredient. The second important ingredient is it should be a property which should have been in this satisfying these 7 ingredients: acquiring, use, possession, disguise, concealment, projection, claiming, etc., etc. Relatable to a scheduled offense notified in the PMLA. That's sine qua non. You cannot bring a general property and a general offense which does not fall within the, suppose it is a property under the general definition, but doesn't meet with the definition of PMLA. It's an offense otherwise under some law, but it does not become a scheduled offense. Can you book that as a proceeds of crime? Court says you cannot book them as proceeds of crime. So it should be a property as defined, and it should be an offense as found in the schedule to the PMLA Act. Once these two things get satisfied, then it becomes proceeds of crime. And the third, last, a vital ingredient which the court says is, without identifying the proceeds of crime, this law cannot get triggered in a case. Very clear. See, there must be an infraction or a contravention or a commission of an offense. There must be a triggering point. So, money laundering of proceeds of crime. And what is proceeds of crime? Property falling under the scheduled offense. And the authority is able to have a seize over it. Unless this cumulatively happens, without identifying a proceeds of crime, if you're going to show about acquisition or use or disguising, case will go for a loss. It's concomitant. It is indispensable, is what the court very, very clearly says. Now comes a very important segment, the sentence. See, now you will understand this is not a pure core crime law, because this is handled by the Enforcement Directorate as authorities. You have an adjudication mechanism under the Act. As we said, attachment, adjudication, and confiscation. These are three vital ingredients under this Act. There is an independent adjudication mechanism under the Act. So you have an adjudicating authority who will adjudicate whether there is a money laundering of proceeds of crime and whether somebody is actually an offender. Independent of the crime committed under the scheduled offense, which will also be an offense under the respective laws, which can be tried in the criminal court. Independent of that. So you have special courts under the Act. So you have an appropriate authority. Then that order will be appealed to the tribunal. You have a PMLA tribunal, if you're agreed. From there, it gives you a statutory appeal to the High Court. And of course, all of us know, even in the absence of further appeal to the Supreme Court or not, you have a right under Article 136. So, this is a mechanism which, this is a critical point which we need to understand. Like customs, like income tax, like GST, like company law, like SEBI, like Competition Commission. This is a separate adjudication mechanism, completely diverse of the core criminal adjudication trial process. So, what is important in this law, which will come up for adjudication, is proceeds of crime. So, when proceeds of crime come up for adjudication, whether it should precede attachment or not is one important question that needs to be addressed in all the cases. See, provisional attachment is a common phenomenon in any economic law. Somebody conducts an income tax raid and they find crores of rupees which are unaccounted. Are you entitled to seize it? You are entitled to attach it. So, can you attach proceeds of crime before holding somebody as a criminal? The law says you can do it. And it devises a mechanism. You are entitled to do provisional attachment. which is valid for 180 days, before which the adjudicating authority should adjudicate upon that. And if they find that the provisional attachment is valid in law, they can confirm it into a final attachment, which will be valid for 365 days or till the trial gets concluded. So you are entitled to do provisional attachment, and you are entitled to do go through the process of adjudication and go for a final attachment. And it says two more things. Within 30 days of provisional attachment, you should send a report and a complaint to the adjudicating authority. You should simultaneously inform the police, who will register a separate case as cognizable or non-cognizable. So there is an obligation under this Act for a simultaneous reference to the police. The jurisdictional police will register this complaint and start the criminal process independently. So there is a question. The normal rule is, unless you file the complaint, unless some sufficient progress is made in the criminal jurisprudence, you should not resort to attachment, was one earlier view. The law got amended to say that if the authorized officer finds that there is an immediate need or a threat, if you don't do a provisional attachment immediately, you can't wait for all these things to happen. You have found out the proceeds of crime and you should attach it. Then there is a golden exception that you can do. You don't have to wait for the process. There again, three things. You can do a provisional attachment for 180 days, lodge a complaint to the police, refer the matter to the police, refer the matter to the adjudicating authority, also send a report to the adjudicating authority for him to decide within 180 days and pass orders, confirming this provisional attachment. So you are given a fair play. So for you to do all this, like any other economic law, there is a process, reasonable belief. Reasons to believe is the starting point. 2, reasons to be recorded is the second point. And 3, this compulsive provisional attachment, immediate provisional attachment cannot be made by a person. No, the designated authority should be additional secretary and law. So it's a responsible person taking a call on the subject. Not everyone can attach it. So these are, therefore, the court says in the judgment, the checks and balances are fairly clear. And therefore, this is not unreasonable, considering the fact that you are allowing this to happen. So plug it at the earliest. This law is both punitive and preventive. We can't overlook the objective that it's preventive in nature. Therefore, do it. A responsible person taking a responsible decision is deemed to be good, and there is a course correction immediately within 6 months if it is bad. And therefore, there are checks and balances. See, so this is how, therefore, from provisional attachment, you move to final attachment. And once final attachment is passed, see the difference between attachment, the Act uses 3 expressions: attachment, possession, and confiscation. These are the 3 important ingredients in the Act. What is attachment? Attachment neither relieves the property from the person nor its ownership. Possession relieves the person from the property, but not the ownership. Confiscation relieves from the person both the ownership and the property, and it vests into the government. These are the 3 stages of the law. See, this is very similar to, as I said, similar to any economic law. Take customs. when a contravention is found, the first stage is detention of the goods. When you detain, you are not considered to be an offender at that point of time because it's under examination. And it will be in your hands. When the contravention is found to have happened, then the detention will translate into a seizure, where there is a prima facie view that you are contravening the law. And therefore, we seize it, but it's still in your custody. Ownership is still with you because we are not adjudicated on that. And when the final adjudication takes place and the contravention gets confirmed, then the authority who passes the order on contravention can also confiscate the property. At that moment, it becomes a property of the government. So this is the syllabus which is copied here. It's not something new. They've been trying to engineer it as with core criminal jurisprudence and take it away from this regulatory preventive exercise into a core criminal jurisprudence. Like one more criminal law. Nothing should happen unless somebody is hanged. You cannot then hold $1 of proceeds of crime in this world, if that's going to be the interpretation. So this clear distinction between core criminal law and a sua juris law, which is both punitive and preventive, which is both regulatory and preventive, punitive, needs to be understood while handling this law. This judgment seeks to really endeavor to draw this line clear, and we should ensure that the lines become more clear and the demarcation is more vivid and undisputed. The attempt will always be to dilute it and take it away from this sphere into the next sphere, which is what I'm going to say in the last 10 minutes, which the other judgment seeks to say from a different reason, from a different perspective, and we'll have to examine that. So this is very, very important. These are the three stages: attachment, possession, and confiscation. So the law drafts a golden rule of exception in all the three stages. If you want to do an immediate attachment, you are entitled to do. If your possession is not the golden rule, but in extraordinary circumstances, if you want to possess, you are entitled to possess. Confiscation follows once adjudication happens. And to say criminal adjudication and trial should get completed will be simply die. So to that extent, there is an area of the matter needs a discussion, which we will do in the last 10 minutes. So they are very, very essential. Core element is these three ingredients of attachment and say possession, and finally confiscation. We'll deal with two more principles and then go to the binomy transaction for 10 minutes. When you do, see, now they were trying to, you understand that this is not core criminal law. The judgment is navigating itself very clearly at every stage. It takes it under the sui generis theory and identifies the components, identifies it and says this is constitutionally valid. And it said so also in the case of search, seizure, and arrest. Like any other economic law, as we said, in the case of doing an attachment, how reasonable belief, you write it. So the same question arose when it comes to search and seizure. Now they said search and seizure should be whether the CRPC process or the non-CRPC process. The court has said it can be non-CRPC process, which is what a notice is issued today on this enforcement case information report, whether it should be given or not. We have to wait and see what the court is going to say on that. But see, the direction is very important. If you are going to intersect core criminal jurisprudence and start seeing it from that kaleidoscope into this law, this will lead in the long run to the dilution of the law and its enforceability. Therefore, the judgment saying today, when you resort to a non-CRPC process, because it's a sua generis law, not core criminal law, whether this judgment is right or wrong is something I leave it to the wisdom of all of you to think. Now, same is that, because like any other economic law, a vexatious search, a vexatious seizure, or a vexatious arrest is impugnable in a court of law. We're actually handling a couple of litigations in the Supreme Court where people have filed such cases, and courts are asking very tough questions against us. The era has changed. Don't think that there's a blanket assumption that anybody can get away under the cloak that he's executing his duties in his official capacity. Cases are all coming up in courts. Now, the final aspect of this law in this judgment is the murder. It deals with bail, it deals with several other things, summons, everything. But I thought with the time available and with overall view, in burden of proof, it again identifies it beautifully under the conventional, traditional economic law route, saying preponderance of probability and not beyond reasonable doubt, which is again that reverse burden and other things is a notice has been ordered today by the Honorable Court. So we'll have to wait and see. So, if you are going to see, when you say every aspect of it is following the economic law course, if the last two of search report and burden of proof is going to be pure criminal law, then it will travel into the whole law. And if it's going to travel this path in PMLA law, what will happen to customs law tomorrow? What will happen to income tax law tomorrow? So any seizure, any confiscation will have to sustain based on the core criminal jurisprudence philosophy, which is not so for last 60 years. So this is a singular difference I see as a professional. These views are my personal views at the moment. The distinction between this judgment and the Binomi Transaction Act. See, the Binomi Transaction Act accepts certain laws are not retrospective, unconstitutional. I'm not going to all those things. But it says two or three things which I'm just putting it for discussion in your minds for you to mull over it. One, it says confiscation proceedings in a Binomi transaction has to follow the core criminal process and need not follow the civil liability process, which is slightly different from what PMLA has decided. And if you ask our personal view, purely a personal view at the moment, as a professional personal view, the PMLA view is in consonance with all the economic laws of this country. Even though forfeiture is also something punitive and therefore falling under Article 21, to say that it should always follow through or await a verdict in the criminal court can have a huge impact in implementing economic laws. It's not going to be very easy. It's not going to be that easy. And similarly, the second point is on the burden of proof, which the Binomi transaction law says should be of that order of core criminal jurisprudence. Whereas economic laws, time and again, have reiterated, there are several Supreme Court judgments, time and again have reiterated preponderance of probability is enough. See, what is the dissecting? This concept is important because I understand people who listen are either lawyers or chartered accountants. So you're all practicing professionals. What is the dissecting line? Take, for example, a customs confiscation. If an infraction is proved under that law and under that parameter, then confiscation happens. When a criminal trial takes place, the person accused may escape the offense notified under that law, because his case could not be proved to the hilt in terms of, beyond reasonable doubt, only shows his personal involvement in the crime to the extent. The contravention of the goods under import is different from the offense committed by the individual who perpetrated this contravention. This is how economic laws make the distinction between the subject matter which it deals with it and the criminal dimensions which flow out of which is tried through procurement. And this is so for income tax, for customs, for GST, for SEBI, for company law, for competition commission, take any regulatory law. Should it be the same for PMLA and binomy transactions, or should it be different? It's the moot question for consideration. So it is only time which will possibly reveal what is in store for all of us. But I thought, because I want to wind up by 6:30, 6:35, something else. So already some 10 minutes have been allotted for questions. It's now 6:20. So this is the broad understanding of both these, very, very broad. I'm not going into that, nor am I going into the details of PMLA. PMLA, there are few more definitions, which in the line of constitutionality, this judgment does not refer to it. But when you do individual cases, you will see how is beneficial owner defined. How is beneficial? What is normal juris understanding of beneficial owner? How is it defined in PMLA? That's a distinction. Similarly, the laundered money in India and the equivalent money outside India, how is it dealt with? It's different. So there are certain nuanced ingredients and intricacies so unique to this law, which I'm not covering it in today's talk, but this will give you an idea that this is nothing but one more core economic law. Do not brand it as a crime law, because Supreme Court has not branded it. It's not a pure crime law. It's a sui generis, as it is both preventive and also punitive. Therefore, it is partly regulatory and therefore partly crime. So this basic distinction should always be borne in mind when you pursue this law, in its approach, in its advice, in its practice, in its implementation, and in its enforcement. With these words, I thank my good friend Arun Giri, who has always been a great supporter of me in delivering various lectures, and Taxsutra is not new to me. I've been doing it for years together. And happy talking to all of you. A couple of questions, I'll try to take it. And if I know the answers, I will tell you immediately, or else I'll work on it and then come back. Thanks again to all of you. Namaste. Arun? Arun?
Yes, sir.
Yeah.
Sorry,
I
sir.
move.
I was on mute, sir. Sorry for that.
No problem. I've concluded.
Yes, sir. Sir, thank you so much, sir. So really sorry I was on mute. Really sorry for that. I was also just saying hi, but sorry. So we do have quite a few questions, sir. Shall we do the questions?
Yeah.
Okay. So the first question is, can money transferred as license fee in foreign currency for dispute?
I don't want to take individual questions. If they have any questions on basic law, I'll handle it. I don't want to advise or because considering the position I hold, and I don't want to dealing such cases in courts. So let me not offer any consultation or advice. Sorry. Please ask core questions in whatever we have discussed. That's my only request. Yeah, go ahead.
So the next question is, the twin conditions under section 45 is hold valid. Do you think that lower courts will give the bail now even after the twin conditions are said to be valid?
You are asking me to speculate, which I don't want to do.
Okay, so,
Yeah.
so then sorry,
Yeah.
sir, you were saying something.
No, as I said, don't bring a specific case for discussion. I do not want to get into it because we may be doing those matters. So I don't want, and it's a growing law. So we should not be offering specific advice on specific questions. If you got a general doubt, please raise it. Otherwise, we can even wind it up. There's nothing wrong about it.
Okay, sir. So one question is, will the IBC 2016 continue to override the PMLA Act?
There are judgments of the Supreme Court defining the scope of 238. Okay, so
Okay, sir.
So in the areas which will govern IBC, see, this notwithstanding is something we should understand it very clearly. This is something I can assist you because at least we are taking that position in courts. This non-obstinate is not subsuming every law or making every law irrelevant. That's not how Supreme Court has also interpreted 238. To the extent where it is connected with IBC and there is an overlap. And to that extent, if the other law is in divergence to IBC will. This has to be understood from that kaleidoscope. This threshold filter cannot be diluted. Something concerning with IBC, if there is some other law dealing with it for some reason, and you find a divergence between that and 238 will dominate. Not a money laundering to say that you can launder money, IBC will still prevail, and therefore IBC will subsume money laundering law. It's far-fetched. Definitely far-fetched.
Right, sir. So one participant is asking, what is your take on the review notice issued by the Supreme Court today?
We should not speculate. It's a court process. Let's wait and see what happens. I have already given a menu as to what these judgments say and what judgments have been saying in economics. So it's a defining moment. We will come to know at some point of time. What is the status of these two laws? How do you treat this law? How do you designate its status? That's going to be very critical. And we only hope it retains its status as an economic law rather than a core criminal law. That's our hope. And anybody who appears for the government will endeavor that pursuit. Let's see what happens.
Right, sir. So shall we take any more questions? Because we have so many of them.
Oh, then mail it to me. I'll see what I can do. I mean, because many of them will be advisory and individual questions. I don't want to get into it.
Right, sir. Right. Okay, sir. Thank you so much, sir. I mean, this was quite a microscopic dissection on the topic, sir. And we're so grateful to you, sir. for taking out, your time, which is so precious
It's our duty.
for us, sir. So we are really, really grateful to you, sir. Thank you. Thank you so much for imparting your wisdom to us today. It was truly insightful, sir.
Thank you. Namaste to all my friends for the support. Namaste. Bye.
Thank you, sir. Thank you.
Thank you.